the outset, I'd like to say that I'm extremely overwhelmed and I don't have words right now because such a warm welcome has been given to me by such a motivated and dynamic team of Aasraa. And I'm truly privileged to be amongst you all because since I've come to Hyderabad, I've moved to Hyderabad and taken up the responsibility of becoming a registrar here. I really did not get an opportunity because I was looking for one to meet with the dynamic lawyers, people who are working in this direction, and people who are motivated and trying to grow the culture of arbitration and mediation, whether it's in the consumer forum or in any kind of forum or a court. Because the idea at the end of the day is to increase access to justice, and that more and more people should really be able to take benefits from the ADR, which is alternative dispute resolution. Now the problem that arises is that many of us really do not know what ADR is. And I personally have an issue with calling it an ADR because unfortunately for a very long time, people has been accepting it as alternative to justice. Whereas I personally feel we should not treat it as an alternative to justice. We must treat it as a preferred or primary mode of dispute resolution. Now, why should we treat it as a primary or preferred mode of dispute resolution? People have this notion, normally a layman, when a dispute were to arise, would really think of going to the court of law for getting justice. But the problem is, when you approach a court of law, because of the protracted litigation and overburdened judiciary, the problem that arises is that, a common man doesn't really get justice pretty fast. And there's a very old saying that justice delayed is justice denied. So the idea is to get justice at the earliest. Now that's when arbitration and mediation kicks in. Now how mediation and arbitration can really solve the dispute of a common man? Since your organization has been working dedicatedly in the field of consumer disputes, a common consumer will go to the consumer court, and sir is the best person to tell us the kind of pressure that is there on judges also. Sitting judges have to deal with hundreds of cases every day. And how do they do it? I mean, it's humanly impossible. But still, sir has been giving, excellent judgments. I've read about sir on Google, and the commendable work that he has done in this field. And Aasraa, sir was telling me, not that I have had an opportunity to work with Aasraa, and hopefully we will really work together to promote the cause of arbitration and mediation. But the thing is that arbitration and mediation can really help the courts and the common man, be it consumer disputes or any kind of disputes, because there are certain reasons why arbitration and mediation are better than court. Now those reasons I will list out. But before I go there, I will press rewind and I'll go a step back. And I'd like to tell you what arbitration is, what mediation is. Normally I'm sure everybody understands, but I will just try to define it in my own manner. And I'm very comfortable with Hindi, Urdu also, by the way. Telugu I'm learning kuncham little bit. So, and I really want to connect with the local people, with all of you, because the center is not belonging to one particular class of people or lawyers. It's for each and every one of you. And with this, I would also like to extend an invitation for each and every member of Aasraa, as well as all local lawyers of Telangana and Andhra Pradesh, because I see that both the states have been very supportive to us. And the idea is to first do capacity building in these states and to get lawyers with us, because I think without their support, IAMC will not be able to achieve its goal, which is to institutionalize arbitration and mediation in India and to make IAMC a world-class institution. Now coming to the main part, when I was telling you what arbitration and what mediation is. Normally, like I said, in a contract between two parties, if a dispute arises, if one party is not making payments to the other party, or if there is any dispute that happens, you go to the court of law.
Yes.
But what we do is, to promote arbitration, we put an arbitration clause or a mediation clause in that contract. This is called a dispute resolution clause. Now, once you put a dispute resolution clause in that contract and you say that tomorrow if any disputes will arise, we will go to IAMC, which is International Arbitration and Mediation Center, and the dispute shall be resolved under the administration of IAMC. Now imagine tomorrow dispute happens, one of the parties not making payments to the other party. Now you don't have to go to the court for justice. You can simply write a notice to the other side saying that I am invoking my arbitration clause or my mediation clause and I am going to go to IAMC, and then you cannot approach the court. Now, why should you come to IAMC and not go to the court? The answer to that question is, first, it is faster. Now, how is it fast? How can somebody guarantee that, it's going to be resolved faster than the court? Under the Arbitration and Conciliation Act, which is the law which governs arbitration in India, there's a time period which was introduced in 2015, from 23rd October 2015, that each and every dispute has to be decided in an arbitration within a period of 1 year. Later on, the 2019 amendment changed the timeline, and now it is 18 months, which is 6 months for filing the pleadings and 1 year for passing of the award. So imagine your whole dispute will be finished within 1.5 years. That's the upper limit. It can finish earlier also. So that's the first part where arbitration comes in, and it makes it easier and faster and expeditious for you to get justice within 1.5 years. Because really all of you as lawyers would know, in court sometimes it may take forever. And I was reading one of the case where some of the generations were fighting over a dispute. So I mean, I'm not criticizing court frankly, but all I'm saying is that courts need the support of arbitration and mediation. And that can only happen when we change our mindset. And the only problem is awareness. We really do not know how arbitration and mediation can help us. Because we feel, oh, what if an arbitrator passes an award? Can it be enforced? Is this a proper judgment, or it's just So these are the issues which are there in our mind. I'm going to clarify quickly. The second reason why arbitration is better than litigation and should be preferred is because it is cost effective. Because in courts, like I said, because there is too much of delay, you end up paying more. Arbitrations are much cheaper, and mediation is the cheapest. And mediation is the fastest. Because in a mediation, you may resolve a dispute in just 3 months or in 2-3 meetings. And the beauty about mediation is that the relationship between the parties, it sustains. You really do not end up fighting. You separate the people from the problem. Problem is resolved, the relationship stays. Unlike courts where no matter who wins, both the parties lose. Because the relationship comes to a halt. So that's the beauty about mediation, how it really can maintain relationships also. It is very cheap in comparison, inexpensive rather, I would not say the word cheap, it's inexpensive. It's more affordable by the parties, and it's faster because you're getting a dispute resolved in no time. Now the other thing is that arbitration, apart from being more accessible and more affordable, the beauty about arbitration is that it is confidential. Now imagine there is a dispute between 2 companies or 2 entities. If that dispute is going on between 2 parties in the court of law, my brothers and sisters from media would obviously understand and agree that what we have seen is that it's being reported every day. It's a discussion of public debate. So sometimes companies do not want certain information, certain cases to come out in the public. Maybe it's a family dispute or a dispute arising out of a business family or a trust. Their reputation is at stake. Because what happens is, if their dispute comes to the public knowledge, even their stock gets affected. The prices of their share keeps fluctuating. So they don't want the dispute should be discussed in the public. But it cannot be stopped if it's in a court of law. That's when arbitration helps, and that's when mediation helps, because arbitration and mediation are confidential. Anything that is happening in an arbitration or a mediation is within the 4 corners of the room, and no third party gets to know what documents were shared, what happened. Even the award, which is the final judgment, which is passed by the arbitrator, it's confidential. You will not be able to access it anywhere. Like you access judgments on Indian Qanun or SCC or High Court website. So that's another beauty about mediation and arbitration. Apart from the timelines that I have said, the less expensive and confidential nature, the beauty about arbitration and mediation is party autonomy. Now, what do you understand by party autonomy? Party autonomy essentially means that freedom of parties. So parties decide how they want to resolve the dispute, rather than the court or the judge deciding that this is how your dispute will be resolved. In an arbitration, parties can choose their venue. They can say, oh, today we want to do the arbitration in a 5-star hotel. They can go there, sit comfortably. You don't have to wear black and white. You have to be very comfortable, and you can have tea, coffee, and the discussion can go on and on. That's the beauty. That's the flexibility which arbitration provides. Unlike a court where you go, sometimes your matters may not be heard. Next date may be after 6 months. Here what you can do is, you can have the arbitrator for 6 days and finish the arbitration at a stretch. Because an arbitrator who's being appointed by the parties, he's a judge in that particular case. He may not be a judge necessarily. He may be you or any of us. It may be an advocate who's being appointed as an arbitrator to resolve a particular dispute. But arbitrator is the creator of an agreement. Arbitrator derives all powers from that contract only. Because I said initially in the very beginning that the mediation and arbitration kicks in only when you have put it in the arbitration clause in the contract. If in the contract you don't put it, you really cannot take help of arbitration and mediation. But nowadays, at least in my experience as a lawyer, I've done arbitrations internationally as well. What I have seen is that almost in every commercial contract, people are putting arbitration clauses. Sometimes a client comes to us, we presume there is going to be a dispute resolution clause where arbitration is mentioned. So my first advice to all of you, my friends who are here, that whenever you are advising a client, because you are the ones ultimately who will really guide people, because a client may not be able to understand the intricacies of law. So you first advise them at the contract negotiation stage itself that you please put a mediation or arbitration clause, which is a 4 or 5 line, which we have on our website also. If you will open IAMC website, you will see our model clause, so that tomorrow if a dispute arises, you don't have to worry about going to the court. The matter can be resolved at IAMC. That's one part of it. Another aspect is that young lawyers like us, we face issues, unless you are as experienced as Madhav sir, that you will have issues with Evidence Act and CPC. To be a master of the procedure, sometimes we take forever. Even people who are 40, 50 years in the practice would not know a provision in CPC and evidence. But that's the problem. It's more about the process rather than the merits, which should not be the case. I remember Justice Krishna Iyer, one of the persons I look up to and I have learned too much from. Not that I have met him, but I have read too many of his judgments. Late centenarian Justice Krishna Iyer, who once said, while dealing with a case, because there was a compliance which was not done under the CPC, and he said in that judgment that the law is not a tyranny, but a servant. So processual law, he coined the word processual law instead of procedural law. So what he meant was that, we are only going to treat it as a handmaiden, and we are not going to be bound by the process, because process becomes a punishment, unfortunately, when there are too many laws involved. So the idea is that in arbitration, if you read section 19, it says that CPC and Evidence Act do not apply strictly. So you don't have to worry about the format, font, paper, legal size, no legal size. You can do simple drafting, a proper well-drafted claim, just submit it. There's no registry who's going to raise objections, and it's too much of a task. That's the beauty about arbitration and mediation, that things are very flexible. So these are some key reasons why I personally feel that arbitration and mediation in any matter can make a great difference because of these particular factors. Apart from that, it is going to generate a lot of investments. If the mechanism of arbitration and mediation in a given state is robust, investors who are going to invest in that state will be very comfortable, because they know if their money got stuck for some reason, because disputes are inevitable. As lawyers, you would understand better than anyone else. Then they really want to make sure that our money the issue is resolved quickly, which can only happen with arbitration, because courts, they are not very sure how much time. Nobody with certainty can say in a court of law, we can finish a dispute in a year's time or 1.5 years. At least with arbitration, that certainty is there. So as stakeholders, I request you all to consider and please support us, be a part of IAMC, and we are organizing certain events for Bar Association members as well. And anybody you think who should be coming, whoever wants to come, it's your center. I'm saying it again, and I'm glad that I have this platform today. Please feel free to visit IAMC, use our facilities and matters. You can do your conferences, you can do your matters there. And whenever you really want to do some kind of discussion and you want to generate awareness about arbitration or mediation, please discuss with me. I'll be very happy to host all of you. And thank you very, very much. And I congratulate you for this excellent effort. Thank you very much.